Good afternoon, everyone. I'm Ann Wolf. I'm the Education and Events Director for the Contra Costa Bar Association, and I am so excited that we are able to bring you this program today. Legal relief for human trafficking victims, really, really very important. And we've got some amazing advocates with us today for this particular issue, and really want to educate you and make sure that everybody's getting as much relief for human trafficking victims as possible. So this will be the first of two. Next Friday will be the second part. I think they are important to have together, but you know, we'll take what we can. We'll take you as much time as you'd like to give us. And there will be good materials, great materials coming your way. I'll let the speakers talk about that. And so I think that's it for me. I'm going to pass this along to Ashley Bardenquast, who is our criminal section leader, and Ashley will take it from here. Thanks so much.
Thank you, Ann. As Ann said, I am Ashley Bardenquast. I am the leader of the criminal law section for the Contra Costa County Bar Association. Thank you all so much for being here. One of the fun things in doing a webinar is that we can have people from all over who wouldn't be able to make it to Martinez or Contra Costa otherwise. And so I'm just so glad that we're able to do so. As Ann said, this is going to be a two-part webinar series. Today is part one. Next Friday, same time, same place, is part two. So make sure to sign up for the next part if you're interested, or pass it around for another round of people to come and join us. It is going to be an excellent presentation. Plus, we get all of those much sought after MCLE credits, including some ethics and such, because as Ann pointed out, this is a really important topic. Relief for human trafficking survivors, wherever they are in the criminal law process, is so important. And so what I would just like to tell everyone who is here, if you have any questions as they come up during the presentation, please put them in either chat or in the questions and answers area, and then I can read them to the panelists. I see we have one. Will the slides be made available? Will the PowerPoint go out as well as with the materials?
I'm fine.
Not any reason we can't get it out to you then. We'll make sure to get the PowerPoint as well as the other materials out to everyone afterwards. But yeah, if you have any questions through the process, please don't hesitate to put them either in question and answer or in the chat. I will be manning that so that I can give them to our presenters. And with that, I am just going to turn it right over to these fabulous presenters. We have Emily Dahm and Dana Filkowski, and they are going to introduce themselves and then give us some amazing work here. So if anybody has any questions during it or afterwards, email me and we'll go from there. Okay, turning it over to you.
Thank you, Ashley. Good morning, everybody, because it's morning for like another 4 minutes. Dana Filkowski, I've been with the Contra Costa DA's office for 25 years. I prosecuted in almost every assignment in this office. The most meaningful work I ever had the opportunity to do was starting the human trafficking vertical prosecution unit here in 2018, and also managing a federal grant that allowed us to create a sustainable state, federal, and local human trafficking task force that enhances its collaboration with victim service partners in order to investigate and prosecute all forms of human trafficking in our community. I had the pleasure of running into my co-presenter, Emily, first when we had a homicide case together several years ago, and I actually oddly liked her, which is weird, right? Because prosecutors and defense attorneys, we don't like each other, we're adversarial, and sometimes we take that a little too far. But in doing this work, Emily and I had the opportunity to be on the other side from each other in a very interesting child sex trafficking case that was prosecuted both at the state and the federal level. So Emily had co-counsel that was a federal defense attorney. I had to do everything because I work for the county and there's always just one prosecutor ever to do anything. And we started having conversations about some of the issues we're going to be talking about today, which is what happens when my victim is your client. and both as a client for somebody who's in the criminal justice system because they become an accused, somebody who retains counsel as a victim rights attorney. And I see that Justice at Last is here, and I'm working with Justice at Last in that capacity in a labor trafficking case right now. And it's really important for our advocates to understand what the legal rights and remedies are for trafficking survivors, because how can you advocate for them if you don't know what they're entitled to? How can you come to me and say, hello, our client needs her rights respected, and here they are, and we will literally give you a list of everything that we're going to talk about today. That's the handout, including the case law lawyers, so don't try to worry about writing down all the statutory references. And so that's how this training was born, was Emily and I talking about a vacatur petition that she is working on, and my frustration that in the 4 years I ran the human trafficking unit, I've only seen one petition for vacatur. Vacatur is what you get to wipe your client's record clear of any crimes, arrests, or prosecutions that are the direct result of him or her having been a victim of human trafficking. So why are we not seeing requests for that relief coming into the county of Contra Costa? So here's what we're going to be talking about today. Our learning objectives are for all of us at the end of this presentation to be better able to identify the legal protections for our survivors, to describe how being a survivor of human trafficking can be a defense to new criminal charges, to explain how being a survivor of human trafficking can be a factor in reducing a criminal sentence, to demonstrate how survivors of human trafficking can clear their arrest and conviction records, and then to collaborate with more local human trafficking stakeholders. We need to get away from giving people the Polaris 1-800 number, because that rings phones in Washington, D.C. Having been to Polaris at its undisclosed location, where I had to sign a non-disclosure agreement about most of what I saw there, other than to say it's amazing and they do incredible work. What I learned is if you call the 800 number that's on billboards and signs and pamphlets everywhere, you will get a live person who answers the phone, and they will ask you what your zip code is, and they'll look at the list. And I have no idea when that list last was updated, but I know that none of our local service providers in Contra Costa or Alameda counties, I don't think any of us are on that list. So we're not getting the referrals, and our local survivors aren't finding out that there's a place you could go right here in your community to get help right now, as opposed to getting a phone number and telling your story and getting more phone numbers to call and having to tell your story and re-experiencing the trauma every single time you have to tell the story, or maybe not having the opportunity to tell the story again because your trafficker is right there. So what we need everybody to understand right now is that there is relief both at both entry points to California's criminal justice system, both for human trafficking survivors who enter as crime victims and or witnesses. These would be the folks primarily that I'm dealing with. And also for survivors who enter because they were arrested, charged with, or convicted of a crime. And one of the things Emily and I realized is we share the same interests. Very rare that the defense attorneys and prosecutors have common interests, but we both are passionately committed to allowing survivors to exit the life. And they only can do that when they get relief from the consequences that attach to having been victims of human trafficking. So how do I ask one of my survivors to get what they would call a square job if she's got a rap sheet that prevents her ever from getting legitimate employment? Is she locked into commercial sex work? Is he locked into under the table labor agreements? So we really want to make sure that we understand the relief that is available at both of these entry points. So
I'll just hop in real quick, and just for the benefit of everybody who's signed up. Hopefully you signed up for both part 1 and part 2. I'm going to be a lot of window dressing today because this is really, part 1 is really Dana's show. We're focused on today on survivors and victims who enter the criminal justice system as prosecution witnesses, as the named victims in cases. For those of you who are, and I hope even if you don't think you're interested, please stay interested. Part 2, which will be next Friday, will address more the stuff that Dana was just talking about. When you are my client, when you've been charged, you've been accused of a crime, but you are also a trafficking survivor. What are the things that your defense attorney could be doing, should be doing to help you address your prior convictions, deal with your current charges? So we'll talk about that next Friday. But I just wanted to say hi, and I'll talk more next week.
So my part right now is going to be this section here. What is the relief for human trafficking survivors who are crime victims and witnesses? We're going to go over confidentiality, protective orders, courtroom support, Marcy's law, restitution, and new law that allows survivors to receive compensation for lost income. If people have questions during the presentation, I always forget my question if I'm supposed to wait for the end. So go ahead and put it in the chat, and Ashley will let us know what they are. And don't feel afraid to jump in. It's more interesting if it's participatory. We've kind of lost that, having to do everything on Zoom, but at least we can have more people here that way. So first of all, what I want to talk about is what is California's sex and labor trafficking law. There is federal law prohibiting sex and labor trafficking, and it is similar to but different than California's law. Since we're all California practitioners, we will be dealing primarily with victims who are getting pulled into California's criminal justice system. We first need to understand what human trafficking legally is. Penal Code Section 236.1 defines all forms of trafficking: sex trafficking for adults, commercial sexual exploitation for minors, and labor trafficking. Each form of trafficking has the same actus reus, the same criminal conduct, which is depriving a person of or violating their personal liberty. That is the conduct which is punished by this statute. The specific intent requirement is that our defendant have the intent to start or continue one or more of the listed sex crimes in Penal Code Section 236.1 B or C for sex trafficking. Or for labor trafficking, their intent when they deprive our survivor of his or her personal liberty, the offender's intent is to obtain forced labor or services. It's really important to understand the difference between sex trafficking involving minors and sex trafficking involving adults. What we've seen anecdotally in doing this work, and what the legislature attempted to address, and the voters when they gave us this statute, is that once children get recruited into commercial sex work, we can't get them back out. And then when there are fewer consequences as a minor, it is easier to justify continuing that conduct past the age of 18 when those consequences start to accrue, and it really prevents a young person from moving out of this kind of life. So when we have somebody who causes, induces, persuades, or, important, attempts to do any of these things, to persuade a minor to engage in commercial sex with the intent to start or continue one or more of the listed sex crimes. And what we're seeing usually is pimping, pandering, procuring or producing and distributing child pornography. Then stop right there. That is a violation of the child sex trafficking statute. So in the case that Emily and I prosecuted, her client never engaged any child in commercial sex, ever, never did. He tried to. And in California, his attempt to do so was punished as a completed violation of Penal Code Section 236.1C. That crime has a 5-year, 8-year, or 12-year triad. So in California, with all the criminal justice reform, that's a big prison number. It is probation eligible, but the defendant is looking at lifetime 290 registration, so sex offender registration. Now, if the sex trafficking of a minor so much as involves liberty deprivation, I don't have to prove conduct of liberty deprivation, just that the defendant's scheme involved it, then the punishment is 15 to life. So we recently had a case where the defendant had just turned 18, and the girls that he was promoting and profiting from engaging in commercial sex work on and around 23rd Street in Richmond, California at the Civic Center Motel, they were 14, 15, and 16. And he used threats, and he slapped one of the girls And that 18-year-old was looking at potentially 15 to life in state prison. Our public defender's office was apoplectic because I had to have him go back and read some case law and the jury instructions. He kept saying, this isn't human trafficking. And the idea was because the girls all agreed to do it, and a victim's consent, statutorily, a minor's consent is irrelevant. Case law tells us even an adult cannot consent to being a victim of human trafficking. So for those of us who don't work regularly with prosecutors, there's a lot of confusion about when and why I will or won't file a case. So just because your client has been a victim and is comfortable telling her story of exploitation, it does not mean that this will become a criminal prosecution at my office. Prosecutors can only file a criminal charge or permit such charges to remain pending if we have sufficient admissible evidence to support a conviction. And that is, we are held to the highest ethical standard of any form of attorney in the state of California. We are given that obligation by the Business and Professions Code, as well as the American Bar Association professional standards. And that's really important because we're looking at dragging somebody through being accused of a crime, and they should only be dragged into the criminal justice system and remain in the criminal justice system if I, based on my education, training, and experience, see enough evidence to overcome the constitutional presumption of innocence and convince 12 people beyond a reasonable doubt that this person has done what I say this person has done. That is the standard for getting a conviction. We can reconsider a filing during the statute of limitations, which for trafficking is 8 years. So sometimes we get more evidence or different evidence, or sadly, we find out that there are more victims. And so we can have sufficient corroboration that will convince the jury. But there's this myth that you see on TV that a person can go to the DA and say, I want to press charges, or I want to drop charges. I'm a public prosecutor, so I prosecute in the name of the state of the people of the state of California. When you look at our charging documents, that's why they say the people versus. It doesn't say your client versus the defendant. That would be a civil case. And like in a civil case, my job is to do what my client wants, but here, my client is the people of the state of California who always demand that justice is done. And it is not justice to drag somebody into a criminal case if I know I can't get a conviction from 12 people beyond a reasonable doubt. How do we get our witnesses to court? Well, we subpoena them because guess what? Nobody wants to go to court. I don't want to go to court most of the time. And so a subpoena isn't me sending you an engraved invitation or sending your client an engraved invitation. It is a court order for attendance. I can get a warrant of arrest from a judge if I need to and have our witnesses arrested and brought to court. The law has not caught up to where it is for sexual assault and domestic violence survivors who cannot be jailed for contempt for failing to attend when subpoenaed. So human trafficking victims technically can still be put in jail unless and until they testify. We would never do that in our office, but it is the possibility. So if California criminal charges are filed, your client is the victim, or our defense friends like to call them the complaining witness. Your client, that individual, has rights. And because those victim rights are so important, we didn't put them in a statute, we didn't make them suggestions, we put them in California's Constitution, and they're known as Marcy's Law. They are in California Constitution, Article 1, Section 28. I quote it all the time. Love it. Judges roll their eyes at me. I don't care. Victims' rights are in the Constitution. That trumps what my defense attorney friends are saying their clients need based on a statute. It does not trump the United States Constitution, and that's what
I'm going to say. Let me just hop in and say,
Yeah.
U.S. Constitution, due process, right
I
to
was
fair
just
trial,
getting
right to
there.
confrontation
I
with witnesses. So
So the big Constitution that Emily talks about trumps the little Constitution. The federal Constitution supersedes California's, and that is where the defendant's right to due process lives. And so there will always be an advantage to criminal defense attorneys in a criminal trial, and it should be. But in California's Constitution, we find the definition of what a victim is. So who is entitled to these rights? A victim includes any person who suffers direct or threatened harm as a result of crime. But it also includes the spouse, parents, children, siblings, guardian, and lawful representative of any victims who may have already been deceased. So in my homicide case, my victim's grandmother and her mother are the people who get to be heard and have their Marsy's Law rights respected in court at this time. It also includes those folks if our victim is a minor. So the guardians and parents of our minor victims have all of the constitutional rights of victims, including that right to be heard in court. Important to know that victim does not include a person who's in custody for an offense. It does not include the accused. It does not include any person that the court finds would not act in the best interests of a minor victim. So if we have trafficking within a family, then obviously the family members of a minor victim aren't going to be the people getting these rights because they're not going to act in the interests of our victim. In certain cases, we have, and we try not to, and I don't think under current law we will be doing this in the future. But what happens when our victim also is a charged co-defendant? Because in a sex trafficking case, one of the people that the defendant is, the primary trafficker is pimping, has recruited minors into the defendant's stable. And now that person becomes a charged co-defendant in human trafficking. So that person, if accused, but also a charged victim, doesn't end up with the same rights under Marsy's Law. When we have Marsy's Law rights at stake, they can be asserted by our victims directly. They can be asserted by me, the prosecutor, if our victim requests. They can also be asserted by the victim's private attorney. So in my labor trafficking case, Nora Cunningham from Justice at Last, who is a pro bono attorney working as a Marsy's Law attorney for my charged victim, she literally filed a notice of appearance in my criminal case, and they have attended every single appearance in this case for over 2 years. They sit at counsel table with me. The judge sometimes tries to do things in chambers so that the Marsy's Law attorneys aren't involved, but they have the right to be heard. They have the right to participate on behalf of the victim. And I believe that that is a really important right. So I'm complaining, I'm telling the judge, nope, we got to go back out on the record because the victim rights attorney is here and they're going to want to be heard on this. And that's been a really good working relationship for us here because while I'm minding the criminal case, the victim rights attorney is looking into the victim's rights under civil law, under the Fair Employment and Human FEHA, Fair Employment and Housing Administration. Sorry, I had to think about that one for a minute. Also dealing with getting her continued presence and immigration relief and all of those things that are outside my wheelhouse that are really important needs of the victim. The court must act promptly on any victim request for enforcement of Marsy's Law rights. It's a drum I bang constantly, and our judges know that. So if I so much as start to say Marsy's Law, like, okay, I get this all the time. Yes, Ms. Filkowski, we know Ms. Filkowski. So, okay, then we're good. In my office, all of our prosecutors take Marsy's Law rights very seriously, and we have a very aggressive victim witness assistance program. That's a state-funded program that works with victims in our office. And if you want more information on that, the Attorney General's website has a lot of really good information. We will give you the slides, and this will have the link to find out that additional information. Human trafficking victims very often do not want to be identified as human trafficking victims or just exploitation victims. Very often we're not seeing our victims self-identify because part of the exploitation is the belief that you have agreed to all of these things. And there's still so much shame and stigma that attaches to coming into the country as a worker without documentation. So much stigma that attaches to being a person who's engaged in commercial sex work. So a lot of times people need help, but they do not want anyone knowing that they need help. So this idea of confidentiality, I need to tell my story and get help, but I'm not yet ready to engage the criminal justice system. So it's very important to understand that there is a privilege in the evidence code that protects communication between human trafficking victims and human trafficking case workers. And the caseworker has to be a person that meets that statutory definition. So for example, the victim witness advocates at the DA's office will tell trafficking survivors, I don't have privilege, right? Because if the victim discloses something and it's got a brazy component, they have to tell me, I have to tell the defense attorney. But there are in our advocacy organizations, human trafficking caseworkers that have a privilege to refuse to disclose and prevent others from disclosing confidential communications with their human trafficking clients, unless there's a court order. Court orders trump everything. We get the court order. Emily, chime in here if you can think of something other than this. If a criminal defendant's due process rights depend on this information being released, in that circumstance, a judge might order its release, but I've never seen that happen ever. Have you seen it, Emily?
I've not, but I can imagine making that motion in the right case where, for example, my client is, charged with human trafficking, and I have good reason to believe it's not just a fishing expedition, but I have good reason to believe that, let's say, perhaps some exculpatory communications have taken place between the named victim and their caseworker. I think it'd be very similar to like a Hammond analysis where, like in sex cases where you're trying to get the therapy records of the victim. I think the bar would be really high, but not impenetrable. But the bar would be pretty darn high for the defense to get into it.
The judge would have to make a finding after a hearing where everybody has the right to be heard, that the defendant's need for this information outweighs the effect of the disclosure on our victim, the counseling relationship, and the counseling services.
Yeah.
So in the last year, I've lost 3 of our victims. I had a 19-year-old sex trafficking survivor take her life by stepping in front of a train in Livermore. And I've had 2 14 and 15-year-olds lose their lives to overdosing. I went in front of a judge recently to request a protective order in a case that's coming up for trial because the defense wants to know the current location of a 17-year-old who was kidnapped off a street corner in Oakland, brought into Concord, and told that she would be making a pimp $2,000 a night. And she was able to run away and escape and get help before it happened. And she's been struggling with substance abuse because substance abuse, alcohol, and drugs, we know that is how human trafficking survivors are addressing the pain and trauma of having been put through what they've been put through. And we went in camera and made a record for our judge of the fact that we've just lost 3 victims. This has been our experience. And the investigator that has direct contact with this victim who's moved out of state and wants contact from no one, that she is at high risk of serious harm if this information is released. And so the defense was given an opportunity to overcome by presenting their need for the information, and had nothing. They just wanted to know it because they wanted to know it. And the court said not enough. And we were able to protect that information from being released on behalf of our victim.
And for those of you who are interested, 1038.1 in the evidence code lays out the test for disclosure, and it is a balancing test. And again, I would not be surprised if the judge, even if they were inclined to disclose, would potentially say, like Hammond, which is the lawyers here may be familiar, but to say, sure, at the time of trial.
You don't get it before, but you get it right at trial.
You get it right at trial, which I have my own beefs with, but just realistically speaking, I would not be surprised if that ended up being the answer.
Now, one thing that's important to know is you can waive, you can give up this privilege. And I've seen that done once. We were prosecuting a pregnant 18-year-old for child sex trafficking in this situation where she was being pimped by her much older boyfriend. And when he made her pregnant and told her, I will put my name on this baby. We can be a family, but who's going to make us our money? You got to bring somebody in to take your place. And she reached out to a program she'd been in Southern California and grabbed a 16-year-old and got her to come up here, bought her a bus ticket, just as had been done to get her to come up here. And then she, in a recorded interview room, threatened the girl if the girl told on their shared pimp. So now she's looking at 15 to life because the child sex trafficking involves recorded threats. Public defender Jesse Shea, if y'all know him, did a phenomenal job representing this young lady, and came to me and said, this can't be the right thing to do here. And here's what I know from talking to my client. Me hearing it from a lawyer wasn't enough. I told him I'm willing to come off of sex trafficking for this 18-year-old. And also she cut her ankle strap when the judge let her out on home detention and she ran away. So that means, right, new charges of escape. What are we going to do with her? She could go to prison for 15 to life, never ever have a relationship with the baby she's about to have. In talking about what would be the right thing to do here, I told him I need to hear her story from her. So my investigator went to the jail and interviewed her with her attorney sitting there. So we had her represented, so no Fifth or Sixth Amendment issues with us having contact with her. In order for him to feel safe with this, I agreed in writing that the information would be used for settlement purposes only. I would never use this information as part of my efforts to convict this young lady of anything. And because it was in writing, if I broke my word and this writing was shown to any judge, it would be rolled up and I would be soundly beaten with it. No judge would ever allow any information that came directly or indirectly from that to be used in any criminal case, because the victim was induced to give up her right to remain silent and her right to counsel by me having made this promise. When we found out that she had a human trafficking case worker, because she'd been trafficked when she was 14 and 15 and was supposed to go into a residential program, but ran away from that because she met the trafficker online in Antioch, California, for her second round of trafficking, I let Mr. Shea know you can waive confidentiality. And if your advocate writes me a letter, which again, in writing, I promise only to use for purposes of settlement negotiations in this case, not to try to prosecute her at all, then that corroborates what she's telling us. And corroboration is the standard I use for my filing decisions. So I can't file a case if the victim says it happened and the defendant says it didn't happen, because I haven't overcome anything. We're at a tie. We're still, the presumption of innocence is still firmly attached to our defendant. So I got an incredible letter from a human trafficking caseworker laying out this young lady's entire horrific story of abuse, engagement in the dependency and juvenile justice system in Southern California, her compelled testimony against the traffickers that were the only people she ever knew as parents down there, and how that led her to do what she did here. And based on all of that, we agreed that she would plead to a much reduced charge. We would put sentencing over until she had enough time for a paper commitment to pandering. And she would go to Southern California, complete the program that she should have completed in the first case, and have parenting classes and have the baby. And then if she successfully completes and does everything that she's supposed to do, we will stipulate that it had been as though a successful vacatur petition had been filed and granted, and every single aspect of this arrest and prosecution will be wiped off her record. We were the very last case that Judge Judy Johnson heard before she retired from our bench. And we were the only case that was allowed in the courthouse on that day, because it was December of a year ago, December, when COVID was super bad. Off the record, we had Judge Johnson saying, if I had to go out on anything, I want to go out on this. This is amazing what the two of you have done together for this young lady, because we had the shared goal of having her get out of this life. His client was literally our victim. And we're back in about 2 weeks for sentencing, and I expect that she will have earned the relief that we agreed she could get if she did everything right. So that's a really important thing to understand, and a really important conversation to have with prosecutors and for prosecutors to consider as we're doing our best to achieve justice in these cases. When we start a criminal case, there can be protective orders. So a lot of times what we have is our victims being really, really seriously afraid of the reach of the trafficker. A lot of times these folks are gang involved, or they give the inference that they are, and that they have this wide reach. And if I can't get you, I'm gonna have my people get you. And so we can use the court to issue criminal court protective orders that prevent from the suspect from having direct communication with our victim or through another person. I love jail calls for this because there's a recording that says these calls are monitored and recorded by law enforcement. Yes, we really listen to them. And I hear my defendant talking to family members, telling family members to go out and make the victim disappear. Okay, now you've just gotten new charges, not just a new charge for violating the court's order, which is contempt, but this is witness dissuasion, and witness dissuasion by force and violence, or witness dissuasion as part of a conspiracy is a strike. When the cases involve domestic violence, as they often do, because we're seeing a lot of sex trafficking occurring within intimate partner relationships, then the court can issue an emergency protective order. EPOs, emergency protective orders, are only for domestic violence cases. That is literally an officer calling a judge and getting a verbal protective order. The officer fills it out and hands it to the defendant. If we have a case that does not get filed, or sometimes these cases take a long time for us to put together because they're really complicated, our civil attorneys, our victim rights attorneys can go to civil court and get a temporary restraining order followed by an order after hearing under the civil code that can be served on the defendant. If the case is filed, when the case is filed, in every single one of these cases, my clerk types out the protective order and it is attached to the complaint, and it is issued by the judge at the time the defendant is arraigned in court, and defendant is handed his or her copy of it. That is, we can get one of those orders during a prosecution, and we always get them at the time of a plea or a conviction, and they can last up to 10 years. Violation of those orders are a crime, and it allows us to arrest, charge, and convict somebody of something else. Really important to understand and to give your clients this assurance. When the trafficker is served with any of these orders, he or she is prohibited from possessing a firearm. If we have reason to believe that that person has a firearm, I can get law enforcement to write a search warrant. We'll go and get it, and then that's another crime. Felony. One of these prohibited persons possessing a firearm or ammunition gets a new felony under Penal Code Section 29825. Really important, advocacy partners and civil attorneys, to make sure your clients understand that only a judge can grant one of these orders, which means only a judge can change or dismiss it. We see very often that when trafficking, kind of like domestic violence, occurs within relationships where the people are connected and close, or there's complications like family, friends, children in common, that they have a period where they're antagonistic towards each other. And so I've got victims cooperating with law enforcement, and then they rekindle. And then the victim says, I got an order against you, but I'm going to drop it. You can be with me. No, only the judge can change the order. So victims have a right to be heard, which means the victim or the victim's attorney can tell the judge, or can tell me to tell the judge, that the victim does not want the order any longer. But until the judge changes it, if the prohibited person, the person who's got the restraining order served on them, if they're violating any of its terms, they can be arrested and go to jail and be convicted. So if your client wants to change a protective order, make sure you let the prosecutor know, and the judge is the only person who can make that decision. Ashley, you popped back on the screen.
I did, which means that I have a question. The question is, I know that I've had it happen to me, and I'm sure some of the defense attorneys have also had it happen to them, where the complaining witness or alleged victim is there in court and wants to speak with the prosecutor to change those things. And, you know, I've multiple times ended up being the person that they're talking to. And I'm like, you need to speak to a different individual, but when they call victim services, they get nothing. So like, what do you suggest for those circumstances when an individual is in court, trying to go essentially through us to get that contact?
They should just walk right up to the prosecutor and say, this is what I want. Our advocates will tell me, in my office anyway,
Okay.
that the victim doesn't want this. The victim wants to speak at sentencing. I have had numerous times victims in court telling the judge, I don't want what she says. My last victim hated me. Most of my victims hate me because the cases at the time, I'm prosecuting somebody that's a part of their life and they feel guilty. A lot of times with sex trafficking cases, the victim is made to feel I'm the one who sold sex. He was just in the car protecting me. I was supporting us. No, that person is now guilty of pimping and pandering. And this notion that as a twins mom, I get this all the time. What? That's not fair. I'm getting in trouble for this when he did that. We see a lot of that too. And that's just not understanding the law. And feeling guilty and not wanting to identify as a victim and being heard on all of that is an important thing. All victims have the right to be for or against a prosecution. I have a lot of victims when I used to supervise the domestic violence unit, same thing, right? I don't want this. Here's your subpoena. You need to come to court and tell the truth. But if the person's convicted, you have the right to tell the judge you don't want any punishment. And I will make sure I stand right next to you and that the judge hears you on that. And so I think it's really important that if your victim is trying to tell it to the prosecutor through an advocate and isn't being heard, then you can find all of us on the DA website. You can call the main number and figure out who the case is, or say I'm a victim and I want to talk to my prosecutor. One of the people I represent is the victim, but the bigger overall is I represent the people and I have to prosecute crime. So I may not be able to dismiss the case because you don't want it, but if you don't want punishment, that is definitely something the court will listen to at the time of deciding what the punishment will or should be.
Ashley, just on your question, I think Dana's right. If you've got a complaining witness who's been talking to you, the defense attorney, and saying, "Boy, I don't want this order. This is not what I want." And I think we've all had that experience where we say, "Did you talk to the victim's advocate? Have you, and maybe they have, maybe they haven't." But the most effective thing is having them in court to be able to address the court. For those of you who practice out of county, there are different procedures in different counties. So for those of you who go to San Francisco, just an FYI, if you are representing a victim, you're a defense attorney who has a complaining witness in one of these cases, somebody who does not want a protective order that's been issued, there's a special procedure. Those complaining witnesses do need to go through a whole interview with a victim's advocate and then come to court. The court will not hear a request for modifying or terminating a protective order unless the complaining witness has had this conversation with the victim advocate, which usually discusses a safety plan of what, one, let's make sure you're doing this and you're not being coerced or pressured or forced into doing this. This is truly what you want to do. And if you truly want to do this, cool. What's your plan if things go sideways again? And then the matter will be placed on calendar for the specific purpose of asking for the order to be terminated. And the complaining witness will be, everybody gets to ask them questions like, is this really what you want? So that's a little San Francisco special.
Appreciate it.
Formally. Yeah. And I have victims that show up at arraignments and will stand right up in court and say, I don't want that order. And then I usually have a judge that will explain, well, until we get through the prosecution, we're just going to have this and make sure everybody, is safe. And it's nicer when the judge explains it. I will then have that angry person waiting for me in the hallway. And one of my obligations as a prosecutor is to have those angry conversations and to be open and to be transparent and to explain and to answer questions. And so I don't mind that at all. And I think it's really important for all prosecutors to make themselves available for those questions and to explain the whys behind this.
Thank you.
Is that slide. So when our human trafficking survivor has to come to court as a witness, it's really important that the survivor know and all of the people supporting our survivor know that there are protections when you are a witness in a case like this, legal protections that the court has to honor. The court must protect all witnesses from undue harassment or embarrassment. Now, Ashley and Emily get to cross-examine. They get to ask questions and they get to ask hard questions, but they don't get to be mean. They don't get to be condescending. And sometimes we don't mean to, but our tone and our eye rolling, and I will call on that, objection argumentative, or sometimes it gets as far as judge, and it gets corrected, and we'll see that happening sometimes. When we have young witnesses, sometimes we've got trafficking victims and they're 12, 13 years old. Witnesses under 14 get special care in court to protect them from undue harassment or embarrassment. All of our witnesses under the age of 16 are entitled to a non-threatening court environment, and they're entitled to 2 support persons of the victim's own choosing. So very often we'll have our victim advocate offer themselves in that role, and the advocate or a support person literally can come to the stand with the victim. There is nothing scarier than what it feels like to open the door to a courtroom full of people and walk from the door to that chair. Imagine what happens when the bride enters at a wedding, right? All heads turn because everybody wants to see the bride at a trial. Everybody wants to see the victim. And that's a really scary thing to do. And knowing that somebody is walking up there with you, literally having your back, they get to sit behind them in Contra Costa County. They can't touch them, can't talk to them, and the jury's watching to see, but it allows victims the safety, the security to tell their truth. And so we're not doing this to coach the person. And in the beginning, when we had a lot of push at getting the advocates and having this happen, defense attorneys objected to it. And the argument really is, don't you want the victim to feel safe enough to tell the truth? What if the victim's truth exonerates your client, but they don't feel safe in telling that truth? So we want the victim to tell the truth. In Contra Costa, we actually also have a courthouse dog. Bear is a remarkable service animal who has been trained to go to court. We primarily use him with child victims who get to hold his leash. All he does is he goes to the stand with the kid, falls asleep at the kid's feet. He snores and farts, so we have to tell the jury what those sounds are. But it gives, again, no, that the child isn't getting any special treatment. The child is getting something that makes the child feel safe in telling their truth. I have a young boy who saw his mother shot in the head, and he will use Bear when he comes to court to tell what he saw. And he literally couldn't do it without Bear. When we have young trafficking survivors who have to face the person that they thought loved them, and now they're understanding that this was really just exploitation and not a good thing, when they have to look at that person, anything we can do to let that person safely and humanely tell their truth is what we want to do. If the victim wants a parent or another family member instead of the advocate or a friend, that they get to choose. And it's really important for us with trafficking survivors. One of the things I've learned from working with our service providers is when you are a trafficking survivor, you lose all your choices. You lose your autonomy, your agency, your control. So anything we can do to give choice and power back, even so far as with young people, like we call who gets to push the elevator buttons. As a twins mom, that was a huge thing for us. Whose turn is it to push the elevator buttons? Who opens the door? Who sits where? One of the things that we can do in creating the non-threatening court environment, our young witnesses get to rearrange the furniture. They can even ask the judge to take off his or her robe. Anything that helps the victim feel safe in telling their truth. One of the things that our survivors really struggle with is this idea that it's all on me. I'm the one who has to go and say everything that happened. And so we try to talk to our survivors about all of the legal reasons we get to make them just be one piece of the puzzle that shows the big picture to the jury for why the defendant is guilty. Evidence Code Section 1108 is one of the things I get to do in cases like this. I can say the defendant, Ashley's client or Emily's client, he's the kind of guy that would do this. Normally, I can't use the defendant's character to show he did what I've charged him with doing now, because it's super powerful. If you hear somebody did a bad thing before, you're much more likely to think they did it this time. So there are very narrow circumstances where I'm allowed to present that kind of evidence. And human trafficking is, in fact, one of those times. I can use the defendant's character to support our victim's testimony as proof that he's the kind of person that would commit this crime. If this is a case that charges a sex crime like pimping, pandering, or a lot of times there's sexual violence as part of the trafficking scheme, and I can show that the defendant has committed other relevant trafficking or sex crimes, I can show the jury, see, he's the kind of person who would do that. Even better, there's a statute that gives amazing protection to our victims. And the first time I showed this to Emily, she was like, no way. Evidence Code Section 1107.5 prevents from happening that thing that all of our survivors are the most afraid of. This idea that this is your fault. You brought this on yourself. We do not let anybody in a criminal case blame or shame our victims. I'm allowed to bring an expert witness to explain the effects of trafficking on our victims. So the big thing that the defense always wants to hit me with is, she could have left at any time. Why didn't she just leave? Here's my expert who's going to explain that to you. Yay, justice at last. Nora Cunningham gave me a connection to a phenomenal labor trafficking expert. Her name is Professor Annie Isabel Fukushima, who has authored an incredible book called Migrant Crossings. I used her as my expert. She's a university professor. She's one of those academic people. She did an amazing job of explaining to Judge O'Malley what liberty deprivation in the context of being a transnational migrant worker looks like. Why did this woman from Nigeria stay in the house instead of just running right out the front door that was never locked? And that was a really important thing for us to understand in that case.
I just pop in real quick and just say, put a pin on this, folks. We're going to talk about how this can be used for the defense as well next week.
Yes, if you ever represented a domestic violence client who was accused of violence against her abuser, you have the battered women's defense. We have the same thing here. It's not just that I can use this when it's my victim. If it's your client who did something where as a result of having been trafficked, you have the same right to call that witness to explain why your client felt compelled to engage in this criminal conduct. And Emily's going to speak more about that now. This is the actual statute where Emily was shocked and couldn't believe it. As part of,
I got feelings about this one as a defense attorney.
And all defense attorneys will have feelings about it, but it's how I get a lot of our victims in the door. When I can tell them and I can tell the judge, and then they read it, they're like, no, and the defense is like, no, and then everybody reads it and goes, oh. Evidence Code Section 1161B means nobody can use the victim's sexual history or history of engaging in commercial sex acts to attack her credibility or character. Even better, a recent case says, you know what history means? It means everything before she took the stand in this case. So, and this is where Emily's going to start tensing up. So you want to say, if you're a defense attorney, that my client's conduct did not induce this person to become a commercial sex worker. They were already selling sex. Can't do it.
And or
even
look,
better,
they continue.
She went right back to selling sex after my client was incarcerated.
Exactly.
So she's the kind of person who would do this. Can't do it. because it means that the jury is just going to think of them, as a lot of the traffickers do, as a disposable person who doesn't matter. They're the kind of person who deserves everything they got because they did it then and they did it now. It fails to appreciate the reality of trafficking survivors, which is that they are often young people with limited education, who are in crisis, who during COVID don't have square jobs, who have criminal histories because of being trafficked and can't get square jobs, who have family, who have kids to support. And as much as they don't want to go back into the life, very often they get pulled back in. And if it's constantly being shoved down their throats, they're never going to get out. And so both the defense and the prosecution have the right to use the statute to prevent us from throwing against the victim the idea that you did it before or you did it after, and therefore you don't get to be a victim. One of the things that I found was phenomenal about Professor Fukushima's book is she talks about the myth of the perfect victim. And all of us in the criminal justice system are guilty of this. If a victim isn't perfect, he or she doesn't get to be a victim at all. And does that mean they don't get any of the relief? Does that mean they don't get the remedies? Does that mean that they don't get the services and support that will help them get out of this situation? It never should mean that. None of our victims are perfect. All of our victims of trafficking are people that had vulnerabilities that were identified and exploited by the traffickers. So every time I have a defense attorney call me to negotiate a trafficking case, and the first thing they want to do is tell me how bad my victim is, it's like, right, I know. All of my victims are train wrecks. That's why your client chose her. That's why your client picked him. So that's not going to be something that the jury will ever get to hear about. And it's not something that's going to be an impact on how I negotiate this case. After conviction, victims have really important rights as well. The most important right is to restitution. We find the restitution laws both in California's Constitution, right? So they trump statutes, but also in Penal Code Section 1202.4. And a defendant is entitled, the defendant is court ordered as part of being convicted, either by plea or by a jury. The judge will order the defendant to pay full restitution for all economic losses suffered as a result of crime. This list right here is in the Penal Code, and guess what? It's an includes but not limited to list. I, as a prosecutor, can get creative in what the victim needs in order to be made whole from having been a trafficking survivor. It includes lost wages, moving or security expenses, counseling, medical treatment, the value of stolen, lost, or damaged property, and justice at last, folks. If you are a victim rights attorney, I can have the defendant ordered to pay your costs and fees. I'm working on Nora to get me what the value of her several years of representation is to our victim there, because our defendant family, they have the means to pay it. So even though you are a nonprofit pro bono law firm, this way you can help even more trafficking survivors. So I definitely want, as part of our restitution award, an award for victim rights attorney fees. This case, my labor trafficking case, is going to trial entirely over the restitution. This was a labor trafficking victim who was brought from another country to be a nanny for a family in Contra Costa County. And she worked 24 hours a day, 7 days a week, and slept on the floor, and didn't have, was never paid in American dollars. A small amount of Nigerian money was paid into an account in Nigeria so that her college-aged daughter had some support. It was 50,000 Naira a month, which sounds like a lot till we use the US dollars calculator and we find out it's about $147 a month to be a nanny to triplets. I think my Starbucks bill is more than that. And the reality is that she is entitled under California law to minimum wage. And so the restitution is literally the value under California law as calculated by the California Department of Industrial Relations. What was the value of her labor during the period of time she worked for them? It's over $200,000. The goal of this prosecution is to make the victim whole. I don't need these people necessarily to go to prison, but they're going to pay her back. and it's going to trial solely over restitution. And interesting, one of the things that our victim rights attorney has to be vigilant on is the court is sort of curious to know, can't we come up with a lesser number of restitution? Maybe the case could settle. Am I allowed to do that under the Constitution? No. Marcy's law says the victim is entitled to full restitution for all economic losses she suffered as a result of crime. Even if I want to negotiate the restitution, they offered us 50 grand against the 200. It's not a civil case, folks. It's a criminal case. I am not allowed to negotiate the amount of restitution. We will have a hearing on it. The court will have to find all of the facts that support that this is how much she worked and this is what the value is. And our judge has intimated that maybe I don't find those facts. Okay, maybe you don't, but we're still going to court and we're still going to have a hearing. And guess who gets to help present the hearing? My pro bono victim rights attorney, who gets to then bill the defendant for having done that. Compensation for lost income. This is a really new statute. There's no case law on it. There's no real guidance on how we get this. I've asked my victim witness people if anybody's asked for this and how we're supposed to get this, and I don't really know. So again, I think that we go to the website and look for relief here or look for guidance here, and somebody's got to be the first one to do this so that we can get some case law on it. But a trafficking victim can apply to the California Victim Compensation Board, which is a state board, has nothing to do with me, for lost income during the time he or she was trafficked. They can ask for up to 40 hours a week using the California minimum wage laws to calculate the value of their actual labor, up to $10,000 a year for up to 2 years. And here are the government code sections that give us that. The idea is if you are a victim of human trafficking and you are engaged in commercial sex work or labor, forced labor for somebody else, then you are not getting the benefit of what California law says your labor was worth. And so California will give it to you up to $20,000 because this allows survivors to start over. One of the reasons that we're fighting so hard for the restitution amount in my labor trafficking case, my domestic servitude case is, can you imagine what a $200,000 restitution payment would do to a victim who underwent everything and endured everything she had to endure for 2 years in terms of letting her start over and support the 2 children that she still has living back in Nigeria. So these are really important things for us to understand, and I encourage everybody to take a look at this and see when there is the right case for pushing for this so that we can get more case law on it telling us how to use it. We're going to stop here and see if there are any questions because our next section is Emily's section. And apparently I am super caffeinated and talked more than I talked faster than I thought I would talk. But are there any questions? There are 20 of you, so just
well, I'm getting through all of that. I know we were worried about time, but we definitely do still have some, right? We aren't technically due to be done until 1:15. Right. I don't see any questions in the chat or in the question and answer area. Thank you, Emily, for posting the updated link to that page in the chat. That's very helpful. Yeah, I don't see any questions here, but there's definitely a lot to chew over here and to take a look at.
Yeah. One of the things that we're going to send to you is a list of the victim service providers, both in Contra, Costa, and Alameda counties. I know there are some folks from other areas here, but we just wanted everybody to know where the local relief is. And we recognize very often that the first disclosure witness may not be law enforcement. I'm teaching a class in 2 weeks, and so this is at the top of my brain right now since I'm writing slides on it. In the case that Emily and I shared. The victims in this, the primary victims in this case were a 10 and 11-year-old girl and their mom. They were at work with mom. Mom was undocumented, and she worked for a janitorial service cleaning an office building in Walnut Creek after hours. Emily's client was an affluent oral surgeon who went to Yale, had an addiction to ecstasy and a worse addiction to child sex and child pornography, and became convinced that what he really, really wanted more than anything was an Airbnb that had 3 10-year-olds in it, for when he decided to avail himself of those little girls. And he had been spending a tremendous amount of money and hiding it from his wife and the rest of his family, trying to make this happen at 2 levels, and never actually able to make it happen. And that night he went to talk to his accountant because he was really in trouble financially. And
yeah, that's all very, really, it was all very good way to get one in debt very quickly.
Yes, it was literally hundreds of thousands of dollars, including transferring US currency into 24-karat gold bars and coins, because one opportunity was through China, and they wanted untraceable funds, and coins and gold bars are just that. And so in this case, he went to see his accountant in December of 2019 after hours. It was literally a dark and rainy night. And this was at the Shadelands office complex, which is way out Ignacio Valley Road for folks that are from Contra Costa County. And after hours, there's nobody out there. There's no reason to be out there. It's all medical office buildings. And as the accountant about 8:30 at night is walking Emily's client out of the building, he sees my victim, Claudia, and her 2 girls, and he wants to talk to the girls. Claudia doesn't speak any English, but the girls have been raised that you don't talk to strangers. And so they ask their mom if it's okay. And he sees that they're taking out the trash. They're putting all the emptying the waste cans into a big sort of dumpster thing. And he talks to the girls and he's nice to them and asks questions like, do you come to work with your mom a lot? And what are you guys doing? And that sort of thing. And then he waits in his car. He figures out where the dumpster is. He gambles that they're going to come out this side door to push the trash out. Surveillance cameras on the building see him peeking through the window a couple times, looking to see if they're in there. It's kind of creepy. And about 20 minutes later, my victim and her 2 little girls pushed the trash out. And he zoomed up in his car, grabbed mom by the arm, and tried to pull her toward the car.
I dispute that fact.
Yeah, she didn't understand the words he was saying. Her 11-year-old explained, and actually was yelling at mama, no, this time don't say okay. Because sometimes when mom doesn't understand, she just says okay. Mama, this time don't say okay. Because what he was saying is, I will give you $40,000 for your girls, for one night with your girls. And he asked the girls, I'll be your new daddy. And the 11-year-old said, we already have a daddy. No, no, no. And then just then the door opens and somebody else who does the janitorial work walked out. Light shines on everybody. He panicked, jumped in his car and drove off. Our Claudia, so shaken and upset that she couldn't enter the code to get back into the building. The accountant saw her. Everybody's adopted this family for Christmas and they were nice to the family. And so they're like, what happened? What happened? And the man called the police. The accountant called the police, otherwise she never would have. God love brand new recruits from Walnut Creek PD who have to work weekend graves, Friday, Saturday, Sunday. So I had 2 brand new patrol officers who had no idea what kind of crime this could be. They came up with, well, he grabbed your arm. I guess that could be a battery. So they asked Claudia to make a citizen's arrest because he was still in the parking lot. So she did. And of course, he immediately posted bail. Then we found out later that night, he used his cell phone to book a flight to Cambodia. Emily, what do we find in Cambodia?
Nothing.
Yes.
Not a goddamn thing.
Yes. But the reason people go to Cambodia is child sex brothels. And this case came about after Contra Costa had the state, federal, and local human trafficking task force. We've been up and running about a year. So on a Friday night, this probably would have gone nowhere. Misdemeanor arrest. It was on the no complaint filed desk. It was eventually going to make its way to our misdemeanor prosecutions in like a year for no charges to be filed. Except on Monday, this happened a Friday night. On Monday, Claudia walked into the Concord Family Justice Center in Spanish and asked for help. And in Spanish, she told the whole story. And at 6:30 at night, I get a call on my personal cell phone from the Family Justice Center director, because they run our human trafficking multidisciplinary team, which is where we have bi-monthly meetings of of law enforcement, prosecutors, social service, and advocacy partners to roundtable complex cases of trafficking. So they knew we had a task force. And I get the story and I get told what I get told all the time. You have to do something. And mind you, I was already in trial. The reason I was still at the office, I was in trial at that moment. I made 2 phone calls. I called my investigator, who immediately stood up the human trafficking task force. And I called one of our advocacy partners, Community Violence Solutions. They are one of our local human trafficking advocacy organizations here in Contra Costa, and they run our Children's Interview Center. By Tuesday morning, we had an ops plan with state, federal, and local prosecutors. One of the things that he told the accountant, because we sent Walnut Creek PD back to re-interview him, was he was going to go to China. So Homeland Security checked border crossings for us. I didn't even know they could do this. And that's how we found out he boarded a flight the next day to Cambodia through Hong Kong.
I was going to say, Ashley, I would just interrupt the very detailed story of my client's guilt. We actually have a question.
Oh, good.
Yes, we do. I was just about to see if I could do a pause. It sounds like the question here is, how do we prove sufficiently to trigger the statutes just discussed that a client is a human trafficking survivor if they're charged in a non-sex case that has no connection to the client's charges?
Yeah, and we'll end up
Also,
talking.
Time check is it's 1:03.
Okay,
We'll talk a lot more about that next session, because that's going to be an issue, particularly for folks trying to vacate prior convictions. But this is where that resource list, I mean, obviously, one, you need to talk to your client. And obviously, if your client is telling you facts that are leading you to believe that your client is a victim of human trafficking, you have a duty to follow up on that. We'll talk a lot more about that next week. But this is that's a great opportunity to start getting a lot of these organizations who focus on human traffic victims involved, and get them to be able to get your client the services that they need. And then there are those folks can also attest to your client's status as a human trafficking victim. They have the expertise, the experience, and the knowledge to help us, particularly criminal defense attorneys, because we're not used to doing this, to tell us, yeah, your client is a victim. Your client has been through some stuff. You need to help support them. Here are some of the services and resources that are available to them. And, here are the people who can actually attest to your client's status, so that you can take that information and present it to the parties you need to help your client get the best outcome in their case.
Yes.
So
I'm really looking forward to that information, particularly improving that nexus, because I know that that's often the hard and fast. And yeah. Dana said today, right, that drug use and alcohol use is a very common way that survivors do kind of deal with their trauma. And, I've definitely seen different cases where even in a veterans court or in a mental health court, bringing up these kind of impacts on behavior in intoxication-based cases, whether it's a DUI or a drunken public or some kind of activity, that sometimes that nexus isn't accepted. And so I'm looking forward to that conversation. If I could ask a follow-up on the shield of not saying that any behavior before or after, the incident in question is permitted to be brought up. Is that block for the argument as an entirety? Or is that just for, speaking to the individual in question, right? Is it a blocked argument or just a level of questions?
So I would use this emotion as a motion in limine. So I would make a motion to prevent you from asking my witness or introducing any evidence that relates to whether the victim in this case has a history of or has presently engaged in commercial sex work. And years ago, I did a trial before we had the statute where it would be a sex trafficking case today. I had my defendant had impersonated a Richmond police officer and was picking up commercial sex workers on 23rd Street and International in Oakland and violently raping them and then throwing them out of the car naked in an industrial section of Richmond. And I had 5 women who we were able to have come forward and testify. Very, very good public defender, Michelle Dawson, did an excellent job for her client, who unfortunately was convicted, unfortunately for her, and is serving 100 and something years to life. But during that prosecution, what she did was she literally referred to my victims over and over and over as nothing but a prostitute. At one point, I sort of crassically, said she would just start calling them thing 1 and thing 2. But it was this way of dehumanizing these women. It ended up backfiring on her, in my opinion, because it was too much. The jury didn't like it, and I commented on it heavily in my arguments as well. But it's to prevent this idea that the victim does not deserve a prosecution because she's just or nothing but which is something that commercial sex workers have been struggling against. This social condemnation of you deserve what you get. Even picking a jury in that case, at one point I asked, anybody here of the voir dire think that a person who works in prostitution can never be raped? And my response was, wow, that's a lot of hands. Let me get to you. And I had one juror say, I think it'd be like a small claims court matter. And when I said, how many people feel like Mr. Smith? Lots of hands. And so you're looking at this bias against people who've engaged in commercial sex work, that they get what's coming to them. And I guess what the statute's trying to prevent.
So I guess my question is, like, that is kind of one extreme, if you would, but like does the statute block all, I'm thinking of a situation where you have a John who is charged as a pimp, right? And that situation is exactly the circumstance where you would want to show that, in fact, this was not an individual's trafficker, it's a different crime, right? But would that statute block any evidence thereof?
That's it. You would have, like with all evidence, right? You have to show that it's relevant. And in most situations, if you're using it to attack the credibility, in most situations, you'd be using it to attack the credibility of the victim, which is what Emily wanted to do, right?
No, actually, my concern with this statute has nothing to do with attacking the credibility of the victim, because that honestly, that's not what I'm here to do as just a general matter. But my concern with this statute, this is the 1161. This is the no talking about other human trafficking behavior that the alleged victim has engaged in. My concern is that when you're prosecuting somebody for human trafficking and the elements of that crime require that my client, I'm representing the bad guy, so to speak here, that my client has induced, coerced, pressured, or in some way made the complaining witness, either through blunt force or coercion, engage in forced labor, forced sex, you name it, that seems to me as a defense attorney that it would be relevant impeachment information. It would be relevant impeachment to say, or relevant evidence to say, actually, it was not my client's alleged conduct, that created the behavior, the labor, the sexual conduct, that my client did not induce this. This was something that was already ongoing or proceeded after. He was irrelevant to the analysis. So that's why I have the issue, not that I want to be like, look at this awful person who's engaged in commercial sex acts. I mean, no, but I got a client to defend who's facing potentially, depending on the allegations, a life in prison case. And I can't present evidence that in my mind cuts away at one of the fundamental elements the government has to prove beyond a reasonable doubt, this nexus between my client's behavior and the labor, so to speak.
Yeah.
So
Not
I think
this has
your
ever
argument-
happened and therefore,
Yeah,
but just,
I think this is the last thing we can say. So Emily's argument, because Emily's a really good lawyer, would make a judge really take a look at the statute, because she's finding a purpose, a relevance purpose for this evidence that is outside of what 1161B prohibits. I'm not
Got
going to use it to attack the character of the victim. I'm using it to attack the element of inducement. And I think we would end up with maybe a judge agreeing to it and giving a limiting instruction that would have to be carefully crafted. So I think that argument potentially still can be made, but we can't use that to shame the victim.
Right.
So we have a motion to exclude any prior or subsequent engagement in commercial sex work by a victim. So you can't ask it about it, you can't present evidence of it. And then you would make that argument, and then we'd have to have a ruling.
Yeah.
got it. So
Really
B is
interesting.
specifically about impeaching the character or
I was gonna-
credibility of the victim versus for other purposes. Got it.
Yeah, this will be a huge in limine fight,
Yep.
you know, in any human trafficking case. This
'Cause-
and this is one that both sides obviously would be very prepared to have by the time you get to trial, because it's going to make a big difference. So
Any last questions? We are just about at time.
Yeah, we're just about at time, as Dana said. It doesn't look like there's anything else. If anybody does have any questions that come up afterward, or any questions generally about these MCLE events, please don't hesitate to contact me. My email is ashley@tully-weiss.com. I'll put it in the chat. And as we kind of mentioned, today was the lead from Dana, from victims and how that happens in court. Next week will be kind of Emily's main bailiwick for how to kind of address some of the questions that were beginning to come up, show that defendants and accused individuals are kind of maybe committing such an offense or involved in activity because they are victims of human trafficking, and what kind of relief that they can get. So we'll get kind of the other side of the courtroom next week.
I hope you all come, and thank you all for coming today.
Yeah,
Excellent. Thank you
everyone.
all. And we'll see you all next week. And again, if you have any questions, you can get to Ashley. My email's everywhere. I'm Ann Wolf. And you can awolf@cccba.org. I'm happy to pass them on as well. And tell your friends to join us next week if you want to. I will tell you that Dana's outline is chock full of information and can help transition those who didn't make it today to fill in the blanks to get to next week. So anyway, tell your friends
Okay.
and colleagues, and maybe not your friends too in this case.
Tell
Anyway, thanks
everybody.
very much, everyone.
Thank you so much.